we would now like to start the first session, which is going to focus on the conceptual discussion on genocide and crimes against humanity. This first session will end at 12:30, and this will include the 15-minute Q&A session, which we will try and our best to have. It will be presented by two keynote speakers, Dr. Mukesh Kapila and Dr. EwelinaUOchab. Now, before I present them, I'd like to introduce them very briefly. Dr. EwelinaUOchab is a lawyer, a human rights advocate, an author, serving as a program lawyer at the IBA's Human Rights Institute and co-founder of the Coalition for Genocide Response. Her work primarily addresses genocide, especially the persecution of ethnic and religious minorities. Key projects involve Daesh in Syria and Iraq, Boko Haram in West Africa, Rohingya in Myanmar, Uyghurs in China, Tigrayans in Ethiopia, and the Hazara in Afghanistan. She also focuses on conflict-related sexual violence and the plight of children in conflicts, including in Ukraine. Dr. Ochab has contributed to over 30 reports to the United Nations, spoken at various international forums, and initiated the proposal for the United Nations International Day commemorating the victims of acts of violence based on religion or belief on August 22nd. Dr. Ochab, thank you for joining us today.
Thank you very much to all organizers for putting together this important event. I arrived in Toronto around 21 hours ago, and in not even a day of being here, I met several people who have very personal stories of persecution, pain and suffering. And it was very moving to learn how they channel their pain and suffering and their experiences of persecution and channel it into advocacy on genocide, atrocity, crimes. So really, really inspiring stories. And hopefully you will also have a chance to meet some of them during lunch break. My presentation is about justice and accountability for the crime of genocide, but also atrocity crimes more broadly. And I will talk about some of the good practices that we've seen over the years. Good practices that we've seen over the years, but also I will mention some of the cases where there is no justice and accountability, and it is very unlikely we'll see any kind of justice and accountability. Last year, together with Lord Alton of Liverpool, we published a book called Getting Away with, no, actually it's not the title. So we wanted to call it Getting Away with Genocide, but unfortunately our publisher didn't approve this title. And we wanted to call it Getting Away with Genocide because that's precisely what's been happening. We've seen so many cases of genocide being perpetrated around the world. In the last 10 years, we've seen several cases, and I would say that even up to 10 cases of genocide or similar atrocity crimes. And unfortunately, justice is not a norm. Justice is an exception. And I will mention some of those cases very briefly. And of course, this is a massive problem. Impunity for past atrocities is an early warning sign and risk factor for further atrocities. So allowing impunity means ultimately that we are allowing yet another wave of atrocities happening in the future. And this is also why we need to focus more on justice and accountability. Yet again, justice and accountability is an exception, it is not a norm. And I wanted to start with the case of the Yazidis in Iraq. And I'm sure that many of you know that back in 2014, Daesh, also called Islamic State, ISIS, ISIL, however we call them, attacked Sinjar. That happened on the 3rd of August 2014. And Daesh killed thousands of men, and to this day we keep finding mass graves in the region. Abducted thousands of women and girls to turn them into sex slaves, and abducted also thousands of boys to turn them into child soldiers. To this day, over 2,700 Yazidi women and children are still missing, and many of them are still alive and are subjected to horrific abuse every single day. And the atrocities against the Yazidis have been recognized as genocide, including by the Canadian government and Canadian Parliament some years ago. And currently it is one of the most recognized genocides in recent years. We have 3 state recognitions of the atrocities as genocide and over a dozen of parliamentary recognitions of the atrocities as genocide. Nonetheless, in terms of justice and accountability, we have not seen that many responses. Of course, majority of the atrocities against the Yazidis were perpetrated in Iraq and in Syria, and both states are not member states of the Rome Statute. So it means that, for example, the International Criminal Court does not have jurisdiction over the situation. The International Criminal Court would have the personal jurisdiction where the Daesh fighters belong to or were citizens of countries that are member states to the Rome Statute, for example, the UK, Germany, and a few other countries. But unfortunately, at the time, the prosecutor of the ICC decided that this jurisdiction, in case of foreign fighters, was too narrow for her to proceed. And indeed, the ICC never really engaged on the topic of the Daesh atrocities. And of course, apart from the ICC, there is no other tribunal that could engage on the topic. There is no other tribunal that could investigate the crimes and prosecute the perpetrators. But nonetheless, there was a very positive step taken by the UN Security Council, and that was to establish a mechanism to collect and preserve the evidence of the atrocities perpetrated by Daesh in Iraq. And it's so-called UNITAD. And this mechanism, which is based in Iraq, has been collecting and preserving the evidence of the atrocities, which is always the first step to ensure justice and accountability in the future. And over recent years, this mechanism has been working with prosecutors in 14 different countries to ensure that the perpetrators are prosecuted by domestic courts using the principle of universal jurisdiction. And you may have heard of some of the cases from Germany. And indeed, German courts have been leading on prosecuting Daesh fighters. They secured at least 3 prosecutions for genocide and at least 5 for crimes against humanity. But we have not seen such response anywhere in the world. There are a few ongoing cases, for example, in the Netherlands, in the US, and a few other countries. But this is, again, an exception rather than a norm. Unfortunately, this mechanism that was established by the UN Security Council most likely will cease to exist next year. And this is on request from the Iraqi government that does not see that this mechanism is needed anymore. And this is a big shame. And there is a lot of fear among the Yazidi community that it means that there will be no justice and accountability in Iraq. And of course, that this impunity will translate into further atrocities in the future. And this is something that we always need to consider and always listen to the victims and survivors and their concerns and fears about what is happening in terms of justice and accountability. So in the case of the Yazidis, there was a big step forward, the establishment of UNITAD, establishment of a mechanism to collect and preserve the evidence of the atrocities. But unfortunately, once this mechanism ceases to exist, that's it. There is no other mechanism to collect and preserve the evidence of the atrocities. But nonetheless, at least at this stage, the evidence collected by UNITAD can be used to prosecute Daesh fighters. And this is something that we would like to see more in other cases as well. And I'll briefly mention the case of the Rohingya Muslims in Myanmar. And I'm sure that you also know what happened to the Rohingyas back in 2016, 2017, when they were attacked by the military, the Tatmadaw, the Myanmar military. And again, we are talking about mass killings, we are talking about rape and sexual abuse, including gang rape. We are talking about forcible displacement of 1 million of people to Bangladesh. And again, these atrocities have been considered against the definition of genocide in Article 2 of the Genocide Convention that Professor already mentioned. And the mechanisms to start collecting and preserving the evidence of the atrocities. Initially, it was a fact-finding mission that collected the evidence and started talking about the possible genocide and crimes against humanity. And subsequently, UN General Assembly established a mechanism to further continue with this work of collection and preservation of the evidence, so-called IIM. And again, this mechanism has been also doing very similar work as UNITAD, collecting the evidence in a way that it can be used to prosecute the perpetrators. However, unfortunately, at this stage, there have not been much happening in terms of prosecuting the perpetrators. So this is something yet to focus on. But at the same time, in the case of the Rohingya genocide, we've seen two very important steps taken. One was to engage the International Court of Justice, and one was to engage the International Criminal Court. And I'll just start with the International Court of Justice. It was Gambia that took Myanmar before the International Court of Justice, and that was for violations of the Genocide Convention. The Gambia, a small, tiny country that said that what is happening to the Rohingyas is genocide, and Myanmar has to be brought to justice for what's happening to them. And indeed, once the case was filed, within the next 2 months, the International Court of Justice heard the evidence and imposed provisional measures on Myanmar to say that you have to cease the persecution of the Rohingyas, you have to ensure that the evidence of the atrocities is not destroyed, and you have to engage further in terms of justice and accountability. Of course, a lot of things happen in Myanmar ever since, and as we know, after the coup, the Tatmadaw, the very perpetrator of the Rohingya genocide, took over the country. So of course we know that there will be no justice and accountability for the Rohingyas in Myanmar. The other step that was also very positive was taken by the International Criminal Court. And with Myanmar, we need to remember that, of course, Myanmar is not a member state or state party to the Rome Statute. So it means that the International Criminal Court doesn't have the territorial jurisdiction over the situation, could not engage this way. But at the same time, over 1 million of the Rohingyas were forced into Bangladesh, and Bangladesh is a state party to the Rome Statute. So early on, the prosecutor of the ICC, Fatou Bensouda, asked a very important question: whether the International Criminal Court can engage where over 1 million of people were forced from non-state party to a state party. And the pre-trial chamber considered the evidence, considered the arguments, and said yes, the ICC should engage and should look into the situation and what happened to the Rohingya, especially as they arrived in Bangladesh, which is a state party to the Rome Statute. But the investigation should go even further. And in order to establish whether it was a forcible displacement, the ICC has to look into what happened in Myanmar, in a country that is not state party to the Rome Statute. So of course this enabled the International Criminal Court to actually start looking into the situation in Myanmar and investigate the situation. And this case is of course ongoing. So that was a very, very positive development, or two very positive steps that were taken towards justice and accountability. And now, of course, both cases are still ongoing, and we are yet to see the results. And at the time, I remember monitoring the situation. I was very pleased with the results. But I never expected seeing anything better, any more proactive responses to the atrocities. But then in 2022, Russia attacked Ukraine, and we've seen unprecedented responses to the atrocities, and especially legal responses to the atrocities. And I brought with me a report that I produced just a week ago, or I published just a week ago, which is a mapping exercise of the legal avenues for justice and accountability and legal avenues taken to date in response to the war in Ukraine. And it is available on our conference website, which is called unitedforukraineconference.com. And it is indeed just a mapping exercise to explain what has been happening. And among others, we've seen, of course, the International Criminal Court engaging on the situation in Ukraine. And that was despite the fact that at the time, Ukraine was not a state party to the Rome Statute. Ukraine had the intention to become a state party to the Rome Statute, but there was still several steps that they had to take domestically before that that was actually successful. But at the same time, over 40 countries referred the situation in Ukraine to the ICC. And this is when the prosecutor actually accepted that, yes, we can engage on the situation in Ukraine and start investigating the situation. And as the International Criminal Court started investigating the situation, they identified 2 cases where they believed that, yes, we can engage there. And earlier this year, that was almost a year from opening a preliminary examination into the situation in Ukraine, the prosecutor, Karim Khan, issued 2 arrest warrants, one for Mr. Putin and one for Ms. Lvova Belova, who is a children commissioner. And that was for the involvement in crimes against humanity and war crimes in relation to the abduction of children from Ukraine to Russia. And of course, once the children were abducted to Russia, they were there subjected to illegal adoptions and forced to live as Russians. So that was the attempt to destroy their Ukrainian identity. So this was a very positive step taken by the International Criminal Court, very quick response from the International Criminal Court. And of course, the International Criminal Court continues to consider other atrocities. And among other atrocities, we can talk about also conflict-related sexual violence. We can talk about the use of starvation as a method of war as well. And those investigations are ongoing. But also in relation to the war in Ukraine, we've seen the involvement of the International Court of Justice. That was on request from Ukraine. And that was because when Russia attacked Ukraine, it was with the argument that Ukraine is committing genocide and Russia is to liberate the Russians who are being subjected to genocide in Ukraine. Of course, Russia didn't produce any kind of evidence why they believe that Ukraine is committing genocide, and not at the beginning of the war, not now, and Ukraine decided to challenge Russia's justification of the war. And this is also why Russia brought proceedings against Russia. Ukraine brought proceedings against Russia before the International Court of Justice. This case is ongoing as well, although very early on the court issued also an order for preliminary measures to say that Russia should cease all military activities and again not destroy the evidence of the atrocities and so on. And apart from that, there have been several other steps taken, and indeed the report goes into over 50 pages of various steps taken. And I will make sure that you have a link to the report as well. But it talks, for example, about domestic investigations initiated by at least 18 countries around the world. So 18 countries around the world started investigating the situation, and especially as refugees from Ukraine were arriving in Poland, Lithuania, UK, and many other countries, the authorities in those countries started, as a matter of principle, collect evidence from the refugees arriving in their countries and make sure that if they have any kind of information about the atrocities, this is preserved as soon as possible to ensure that at some point, it could be used also to prosecute the perpetrators. And over recent months, we've seen also steps taken to use the principle of universal jurisdiction to prosecute the perpetrators. And indeed, 2 organizations submitted evidence to initiate proceedings in Germany, and that's under the principle of universal jurisdiction. There's an ongoing case in Lithuania, also for atrocities perpetrated by Russian troops in Mariupol in Ukraine, and many more. And the example of Ukraine is really unprecedented. We've never seen such legal responses to any other atrocity crimes perpetrated globally. And it should be used as a blueprint for the responses to other atrocities, although it's very unlikely that we'll see anything similar in the future. And that's, again, a big shame. But this is a model to follow, and this is something that we should recreate in response to other atrocities. So these are 3 examples where we've seen some positive responses, and of course, in the case of Ukraine, incredible responses that we should follow in other situations. But unfortunately, again, this is an exception rather than a rule. And I know that I don't have much time, 1 minute left, okay. But I wanted to tell you very briefly about a couple of cases where we have not seen any kind of positive responses, or it is very unlikely we'll see justice and accountability. And I will start with China and the genocide against the Uyghurs there. And of course, there's a lot of evidence of the atrocities against Uyghurs. And if you Google Uyghur genocide, you will see report after report about the abuse of Uyghurs in so-called re-education camps. You will see BBC reporting on rape and sexual violence in the camps and so on. You will see an Uyghur tribunal judgment. You will see the report from Michelle Bachelet and many more. But unfortunately, in terms of justice and accountability in China, nothing is going to happen because, of course, authorities are involved in the atrocities. So, of course, there will be no steps taken on justice and accountability there. And then the International Criminal Court cannot engage. The involvement of the International Court of Justice is very unlikely as well. And then there is no other tribunal that could engage. But what's been happening is that, for example, in Argentina, we've seen steps taken to, for example, use the principle of universal jurisdiction to engage on the case. And indeed, together with my colleagues, we are also submitting an amicus brief in support of that case. And it is really to try to secure some kind of justice and accountability using domestic courts where nothing else is available, or there are no other legal avenues for justice and accountability. And in question time, I can also mention some of the steps that, or some of the attempts to engage the International Court of Criminal Court, but nonetheless unsuccessful to this day. Then very briefly, the situation in Ethiopia. Of course, we are hearing a lot about the situation in Ethiopia, and you would hear definitely about the Tigray War, and I believe there will be also speakers mentioning the situation, explaining what's been happening there. And you will hear that, for example, there was a ceasefire back last year, in November last year, but nonetheless, some of the atrocities are ongoing. For example, the use of rape and sexual violence is ongoing despite the ceasefire. And then after the ceasefire, we started also hearing about further atrocities against Amharas, against protesters, and ongoing atrocities around Ethiopia. But nonetheless, there is very little attention on the situation, and this lack of attention translates into impunity as well, and lack of political will to address the situation. There was a commission of experts on human rights in Ethiopia, and that was established by Human Rights Council, again, to collect some of the evidence, monitor the situation, and then make an assessment of the situation. They publish report after report saying that crimes against humanity are being perpetrated. There is a risk of genocide against Tigrayans, but also against other communities, and nothing was done. And indeed, this year in October, when this mechanism was to be, when the mandate of this mechanism was to be extended, there was no state willing to table a resolution to extend the mandate and ensure that this mechanism can continue doing its work. That includes collection and preservation of the evidence, analysis of the situation, and so on. And then very briefly about the Hazaras in Afghanistan. And again, there will be a speaker discussing the situation of the Hazaras in Afghanistan. Again, we are talking about genocide. We are talking about at least serious risk of genocide, if not already elements of genocide being present. Unfortunately, as the attention from Afghanistan moved on, there is very little being done on the situation. In the UK Parliament, we've done an inquiry into the situation of the Hazaras in Afghanistan, with several recommendations, including for states to take Afghanistan before the International Court of Justice for violations of the Genocide Convention. But unfortunately, there have been no political will to actually engage on this important step. And then in terms of justice and accountability in Afghanistan, we know that this is not going to happen. And there is also very little political will to look into other avenues for justice and accountability. Of course, the situation in Afghanistan is subject to an investigation by the International Criminal Court. So of course, that gives a little bit of hope that maybe the ICC will look into the situation of the Hazaras, although at this stage, the ICC has not identified a case pertaining to the situation of the Hazaras, at least for now. So this is something where civil society organizations can get involved, including by submitting Article 15 communications to the International Criminal Court with further information that can help the ICC to actually formulate a case of genocide or crimes against humanity against the Hazaras. But nonetheless, very little being done to address the situation. I don't have more time, I am being told, so I'll just summarize very briefly. In my presentation, I told you about 3 positive steps, or 3 situations where we've seen positive steps to address horrific atrocities, where a little bit towards justice and accountability has been done, but also 3 cases which happened also in recent years, where almost nothing was done, and there is very little hope for any action towards justice and accountability. And this all despite the fact that in terms of genocide, we have a duty to punish genocide. This is a duty in Article 1 of the Genocide Convention, but as we see, it is not being implemented. And then, just looking more broadly, we know that there are currently attempts to also introduce a convention on crimes against humanity, also imposing duty to punish the crimes against humanity. But seeing the experience with the duty to punish genocide and very little being done to address it, it is very unlikely that even if we have the Convention on Crimes Against Humanity with a clear duty to punish crimes against humanity, not much will happen. So this is why, again, our book was meant to be called Getting Away with Genocide, because this is precisely the message we are sending to the perpetrators. If they commit genocide, but also crimes against humanity, it is very unlikely that they will face any kind of accountability. So thank you very much for listening to me, and if you have any questions, I'll be very happy to respond.